webinar in our Hello everyone, and welcome to the final webinar in our 2020 webinar series titled Using the SOAR Model with SSA Appeals. My name is Pam Hine, Senior Project Associate with the SOAR TA Center, and I will be your moderator today. Before we begin, just a few housekeeping items to review. A quick disclaimer. This training is supported by the Substance Abuse and Mental Health Services Administration and the U.S. Department of Health and Human Services. The contents of this presentation do not necessarily reflect the views or policies of SAMHSA or DHHS. The training should not be considered substitutes for individualized care and treatment decisions. Just a few webinar instructions. As a reminder, your lines will be muted throughout this entire webinar. This webinar is being recorded and will be available for download on the SOAR website soon after. There are a couple of ways you can download the PowerPoint slides and two handouts. One way is by going to the top left of your screen and clicking File, then Save, then Document, or visit the SOAR website at soarworks.prainc.com. Then click Webinars on the left sidebar and choose today's topic. At the conclusion of the webinar, you will be asked to complete a very brief evaluation, which we kindly ask you to complete. And finally, we will save all questions and comments until the end of the presentations, at which time we will review instructions for posing questions to panelists via the Q&A box. So it is our intention that by the end of this webinar, you will learn how to access and utilize the recently updated SOAR TA Center Appeals Toolkit. Our panelists will walk you through a few of the sections and share key strategies for using the SOAR model with appeals, specifically the Reconsideration Appeal and the ALJ Appeals. You'll learn from two panelists how to develop a theory of the case when representing applicants at the ALJ level. And then lastly, we'll share some practice tips for representing applicants with appeals during the COVID-19 pandemic. Our presenters today include Kate Jones, who is a SOAR case manager with Interface Community Services in San Diego, California. Then you'll hear from Jacqueline Darby, supervising advocate with the Community Health Law Project in Trenton, New Jersey, and Karen Dobak, senior paralegal in the Elder Health and Disability Unit with Greater Boston Legal Services in Boston, Massachusetts. And then lastly, Liam Connolly, an outreach social worker with the Healthcare for the Homeless Veterans, also in Boston, Massachusetts. And then again, we'll follow up with, we'll have plenty of time for questions and answers. So giving today's welcome is Asha Stanley with SAMHSA. Asha, would you give our welcome, please?
Thank you, Pam. A warm welcome to all of you joining us today. On behalf of SAMHSA, I would like to welcome you to this webinar titled Using the SOAR Model with SSA Appeals. As many of you know, SOAR helps states and communities increase access to Social Security disability benefits for eligible adults and children who are experiencing or at risk of homelessness and have a serious mental illness, medical impairment, and or a co-occurring substance use disorder. While we do our best to help eligible individuals get approved on the initial application, sometimes the application is denied and we need to help someone through the appeals process. Appeals may also be necessary when we meet someone who has already applied and been denied, or if we were not able to provide sufficient evidence for the initial application. Today's webinar will give you many practical tips and tools to help you better understand how to assist SOAR applicants with appealing SSA denials. I would like to welcome and thank our presenters for your willingness to share your expertise with us. I will turn it back over to Pam Hine, who will be moderating today's webinar.
Thank you so much, Asha, for your welcome and supporting our webinar today. Before we begin, I'll just set the stage with sharing some basic information about the appeals process, knowing that while the SOAR model does everything we can to assist the applicant with being awarded benefits at the earliest possible stage, which is the initial determination. We know that Many of you will assist with the first level of appeal, the reconsideration, and some of you may also be doing administrative law judge hearings by yourself or in partnership with maybe a local legal services organization. So states are increasingly using the SOAR approach to assist with applications in the appeals process, both with the reconsideration and hearings by an administrative law judge. In 2019, 1,529 SOAR-assisted decisions were rendered at the appeals level, with 44% of all reconsideration or ALJ hearings resulting in an allowance. SOAR-assisted appeals take an average of 187 days as compared to the national average hearing processing time of 503 days, resulting in applicants receiving life-saving benefits over 2.5 times faster. We know that there is an appeals backlog, and SOAR providers can absolutely help reduce this backlog by assisting applicants at the earliest possible level, to reiterate again. And just to give you some context, as of March of 2020, there were roughly 575,000 ALJ hearing requests waiting to be scheduled, keeping in mind that in 2019, that number was over 1 million. So we do see that the backlog has decreased significantly, but we know that that is still a very high numbers. And many states are experiencing over 400 days for a hearing to be scheduled. Now, SSA is doing a lot in terms of increasing resources to deal with these backlogs. One in particular I'd like to note is the reintroduction of the reconsideration level in 10 states that were considered prototype states. So in 2019 through early 2020, the states that you see below, Alaska, Alabama, parts of California, specifically Los Angeles, Colorado, Louisiana, Michigan, Missouri, New Hampshire, New York, all have their reconsideration levels reinstated. So if you are in these states, you'll be glad to know that one of our presenters will speak to you more about reconsideration if this is newer to you. So to get things started, by talking about reconsideration, which we know many of you do want to learn more about, I'm going to pass things over to Kate Jones, who will go a little bit more in depth in using the SOAR model with appeals, specifically reconsideration. Kate?
Hi, thank you so much, Pam. My name is Kate Jones. I am a SOAR case manager for Interfaith Community Services here in Escondido, California. And I'm going to talk today about the first level of appeal. The first level of appeal is a reconsideration. And the first slide that's up there right now is an overview of what I'm going to talk about today. But first, I want to talk a little bit about the emotional and mental health effects that a denial can have on our clients and on us as well in our role. We know that a denial is not the end of the road for our clients, but it is really hard to tell a person who has placed their trust in us, that their appeal has been denied. We work with people who have probably not experienced much hope and very used to being told no. So when we do a SOAR application, we often open the door to hope for people who struggle daily with homelessness and serious mental illness. And sometimes our clients, they're actually participating in care for the first time. They're doing everything we ask them to do, attending appointments, they're doing their meds, all of that. And then they get told no. For us ourselves, we put a lot of work and invest a lot in the SOAR application. And, we've entered into a relationship with these people that we are working with, and we hope for them as well. So, when the denial comes, it's really, really hard. We need to remember that this is a huge blow for the people that we work with. So our job becomes, in addition to moving forward with the appeals process, we now need to really work on continuing to motivate and encourage our clients because no is hard to hear. So we're going to talk about the process and the procedures for reconsideration today. And this slide here. So the reconsideration is the first level of appeal, and it is a time-limited thing in that we have 65 days from the date of the denial letter to file a reconsideration. There are going to be times that we are outside of that time limit, and we're going to talk about those in a little bit. So a reconsideration is exactly what that name implies. It is the application goes back to DDS for re-examination, but by a fresh set of eyes. The reconsideration will be worked on by a different DDS examiner and by different medical decision personnel. And one of the really good things about a reconsideration is we can submit new evidence. We can submit new medical corroborative evidence, updated functional information. And another good thing is that it preserves the protected filing date from the initial application. So the reconsideration should be filed online and filed completely at that time to include all forms and documentations. You're going to file all that at the same time, and we're going to talk about that process a little more. So when an initial, there we go, the slides. So when an initial application is denied, we have two options, which is appeal, which is a reconsideration, versus a new application. So again, the pluses of a reconsideration are it lets us beef up that initial application with new evidence, and also it preserves that protected filing date. One thing that we cannot do with a reconsideration is introduce a new diagnosis. We can only address what conditions were filed for initially. So a reconsideration is appropriate if the client meets or equals the listings of the conditions that we filed for. But we have to remember the decision to do an appeal or a new application, that rests with the clients. We want to make sure that we've explained both the appeal versus the new application, and that they understand the reasons for each and they make the decision. And so now we're going to talk about what we do if that 65-day deadline has passed. So sometimes clients are going to come to us after they have filed on their own and have recently received denial. If sometimes we're outside of that 65-day limit. Fortunately, we can attach what is called a good cause letter, and you can see a really excellent example of that up on the slide now. A good cause letter is an explanation of why there is a good reason for not meeting that 65-day deadline. And up here on the slide are some of the reasons. When it says related to the applicant's disability, that means perhaps you have a client who experiences a great deal of paranoia or another aspect of their mental illness that doesn't let them understand or be willing to participate. So those, the ones listed up there are some very good reasons why you would file a good cause letter. So the good cause letter, you need to include that in the reconsideration application. You want to check with your local field office to get an idea of how late they will consider a good cause letter. So here in San Diego, our local field offices won't accept a good cause letter if it is over 120 days after the date of denial letter. So now we have determined if, in fact, the client is appropriate for a reconsideration in that they meet the listings that we filed for and we are either within the 65-day deadline or we have a good cause to file outside that window. The next step in the reconsideration process is we need to figure out why this application, the initial application, was denied. So one of the first things you want to do is you're going to take a look at that denial letter. That letter will list, I do not have COVID. That letter is going to list all the medical evidence that you supplied, all the doctor's offices, visits, hospitals, all of that. It's going to list all of that medical evidence and all the other documents that you submitted in the initial SOAR or that the client submitted when they did it on their own. And it's also going to list the diagnoses that were filed for. The letter is going to say something like, we have determined your condition is not severe enough to keep you from working. while you have some limitations, experience some depression, etc. So one thing to note is that these letters are basically autofilled after the specific things like medical evidence and diagnoses are listed. And it is very frustrating to read these letters because we're thinking to ourselves, wait a minute, we filed for PTSD with psychotic features and the letter's talking about depression and anxiety. So just remember those letters are typically autofilled after a certain point. So once we've read that letter, we're going to order the electronic file from Social Security. Now, the Appeals Toolkit that is part of this presentation, it is an excellent section on how to order the file and how to interpret it. Actually, and it tells you how to open it too, how to open and interpret it once you receive it. So bear in mind there's going to be a lot of possible reasons for denial, like the client does not meet the listings, the client is not insured, the client has too many assets, or a spouse has too much income, that kind of thing. They're the codes that you will see in the electronic file are going to tell you specifically what those reasons for denial are for. So you're going to look at those, you're going to figure out those reasons, and then you're going to be able to address all those reasons when you file your reconsideration. So now that you know the reasons that your client was denied, it is strategy time. We have to plan our strategy for filing this reconsideration, because remember, a reconsideration is not simply, please look at this case again. A reconsideration is an opportunity for us to specifically address the reasons for denial. Like if the decision for denial was medical, we need to supply more evidence in support of the listing, and we need to supply more examples of functional impairments. We can find more corroborative evidence from family and friends. We really need to beef up how it is apparent that the client's illnesses or conditions affect their ability to work. So if the decision is based on another reason, not medical, like Social Security says that the client has too many assets, that kind of thing, and we know and can prove that that is incorrect, then we need to supply that evidence to show that in the reconsideration as well as any medical evidence. So we know the reasons. The client is appropriate for a reconsideration, and we've addressed everything. We've gathered all of our documentation and evidence. Now it is time to actually file the appeal. You're going to do that online, and you're going to do that at iAppeals at SSA.gov. And this process, it allows you to submit all documentation, medical records, everything, all at the same time. So make sure you have everything ready to go, all your ducks in a row before you sit down to file online. The Appeals Toolkit has an excellent section on exactly how to do the iAppeals. It will walk you through the entire process. So that is the process and procedures for filing a reconsideration. Right now, I'd like to share a couple tips I found to be helpful in this process, particularly timing of the filing of your reconsideration. So if you are within the 65-day window, I recommend filing as late as possible in that window. The reason for this is that it gives you more time to develop new evidence. You can build new medical records. You can get the client into more doctor's appointments. You can gather more corroborative evidence, more examples of functional impairment. It just gives you a little bit of time so that you can beef up your evidence. Next, I highly recommend that you schedule, if you're filing for mental health, that you schedule a mental status exam regardless of the last one submitted. And this is especially important with COVID now, because consultative exams are they're canceled here in California, but they're canceled. And so they're not being able to get a current, what they consider current medical status exam unless we provide that. So I recommend getting your client scheduled for one within 90 days. That will absolutely help. Another thing that I think is really important is encourage your client to continue with their care, and do this especially after the initial appeal as well. And the reason for this is that it lets you continue to build records, especially if an appeal becomes necessary. But also what it does is it helps the client move forward, helps them to live their best life if they're willing to participate, obviously. But when it comes down to if they are awarded SSI or SSDI, they're going to have to recertify. So if they can show that they are continuing care but continuing to experience symptoms that prevent them from working, that's going to be helpful to them in the long run. And additionally, address every single decision code that you possibly can in your reconsideration. You want to address everything, answer the questions, submit the proof to refute anything that you possibly can. Excuse me. When you write your MSR initially or for an update with a recon, I recommend doing it with the listings sitting right next to you, and use the language in the listings. Try to find quotations in the medical records that match the language of the listings. When you do that, I also recommend that you date those quotes and attribute them to the doctor who said them. And that makes it much more straightforward for the medical examiner to look at it and then go back to the medical records and find that piece of evidence. And again, try to get your MSR signed by an accepted medical source. That's always very helpful. Next, so the grids will be discussed later on in another segment, so I'm just going to say use the grid if it applies to your client. I also recommend using the grid for initial applications as well. Talk a little bit about COVID-19. Since consultative exams have been canceled, they're making decisions based solely on the evidence that we can supply. So I strongly recommend, again, getting an updated MSC. If you can't, when you're going to work with your clients online and you can't establish a My Social Security account with them, need to get in touch with your local Social Security office to find out how they're handling proving identities, that kind of thing. Here in San Diego, they're requiring people to mail in their actual ID. So I recommend talking with your liaison about that. And doctor's appointments. So doctor's appointments are super, super important for filing for our clients, but with COVID-19, they're all being done over the phone or over the computer, and a lot of our clients simply don't have access to either of those. So I recommend trying to help your client, maybe even have them use your phone for their telehealth, that kind of thing. So a success story. I had a client come to me after his initial application was denied, and he had significant mental health as well as physical health issues. So his initial application was denied, and he came to me and I did a reconsideration. And this was a good example of how an MSR can win the day, because within that MSR I was able to show how he was functionally impaired and unable to work. And we received an approval on his reconsideration. I think it was something 25 days later. And this client is now in the process of leasing up with permanent supportive housing, and he is maintaining all his mental and physical health to the best of his ability and is starting to live his best life. So SOAR really, really works, and SOAR really works with the reconsideration process as well. Thank you so much. The end.
Thank you so much, Kate, for that wonderful presentation. I think you highlighted some aspects of the reconsideration which can be really beneficial to SOAR applicants. One, submitting it with an MSR. The MSR wins the day. I think that is going to be a huge takeaway for folks. Writing an MSR to beef up the case, just one of the strategies that you shared. And also, if you're new to the case at the reconsideration level and you don't have an SSA 1696 appointment of representative form on file, you can actually upload the SSA 1696 with that iAppeals. So that's something that's a little bit different than the initial level when you use the online services. So I just wanted to give a plug for that as well. So again, thank you, Kate, for your tips. We really appreciate it. Next up is Jackie Darby, Supervising Advocate with the Community Health Law Project in Trenton, New Jersey, who will share some of her strategies for how to develop that theory of the case. Jackie?
Thank you. Good afternoon. First question you're probably asking yourself is, what is a case theory and why develop one? When developing your theory of the case, it should be a clear, compelling, concise, and a convincing statement that you develop as to why the ALJ should approve your client. In practicality, your case is really going to be based on your client's answer to one very simple question. Why can't you work? What are the limitations that are keeping that individual from working? There are four main theories we can use. I'm going to go over each one of those. The first one, prove that your condition meets and or equal a disability listing. And for that, you should become familiar with the listings of impairment. The Social Security's handbook of listing of impairments, I refer to it as the Social Security Bible. It's a listing of impairments for each major body system. The listings outline the criteria required to be found disabled under a particular listing. The second one is prove that you grid or out of all work, including past work. And for this, the grid rules are important. Remember, your client has an impairment, but at this point, when you have to use the grids, it's usually because their impairment is not listing level. The grids look at the person's age, their education, and their work history. Say, for instance, you have a client who's age 50 to 54. They're considered an individual approaching advanced age. When this individual has no past work experience or can no longer perform vocationally relevant past work and have no skills that they can transfer to another job, a finding of disabled is usually rendered. Also, if you have an older individual, which Social Security calls advanced age, these are individuals who are 55 or older. They have a limited education and perform unskilled or no work to be found disabled under the grid. There are also allowances for individuals who are high school graduates or more. So you should review the grids. So in developing your theory of the case, you should take into consideration your client's age, work history, and education. This could be your case theory for approval. And then prove your non-exertional limitations prevent you from working. I use Social Security ruling, SSR 8515 a lot. This is a ruling that you use when there are no non-exertional limitations. Now, a non-exertional impairment is defined by Social Security as an impairment that does not directly affect the individual's ability to sit, stand, walk, lift, carry, push, or pull. Examples would be mental health, blindness, deafness, just to give you a few. The last thing you want to look at is you want to prove that your exertional level is less than sedentary. If your work activity is less than sedentary, this falls under the grids as well, and you can't do sedentary. And if you can't do sedentary work, then you can't work at all. You should also familiarize yourself with the 5-step sequential process. This is the evaluation process that the ALJs follow in a set order. Individuals can be approved at steps 3 or 5 of this, so make sure you familiarize yourself with it. So you may be asking yourself, when should you start developing your theory of the case? The development of the theory should start at the first interview. Your interview should be thorough, be nosy, ask a lot of questions. I find in my practice that clients like talking about their impairments. If they don't feel comfortable, they'll let you know. I also let them know that we all have issues, and this helps them feel comfortable. Sometimes they may say, well, I'm sleepy all the time, or, I can't sleep at night. And sometimes I'll chime in and I'll say, well, I have those difficulties too. They see us as a person then, and they're more inclined to open up at that point. My goal when I'm asking the questions is to obtain all the information I can to help me think of, okay, how can I best present this case for this claimant? So in developing your theory of the case, you want to make sure when you're talking to the client during the interview, you want to ask them about all their different treating sources so that you can request those records. Sometimes what the client actually comes into us and say that their impairments are, once we start reading the records and dissecting them, we find out, well, that's not actually what we are going to be able to get them approved on. Most times it's something other than that. Okay. And you should also, again, look at their age and their education and their past relevant work. Now, at the end of that interview, you should have the client sign medical releases for all their treating sources. So what happens after the interview? Think of yourself as a clinical Columbo. This time, we actually become investigators. We're looking at the records. We're dissecting the records. We're looking to see other treating sources. Sometimes the records will lead you to other treating sources that the claimants have seen that because they've seen so many, they just don't recall. It may lead you to other hospitalizations. And then we send the clients releases and have them sign them so that we can obtain those records and build a longitudinal, show the judge how this impairment has progressed over time for this claimant. Okay. You want to get supporting documents, statements from different treating sources. Sometimes the records are vague. As you know, some people actually use check-off boxes instead of giving narratives as to what's actually going on with the claimant. So sometimes we will send letters to them asking for statements regarding their impairment. Sometimes we send a mental ability to do work form, which Karen will speak to you about when she does the second half of this part of the presentation. Sometimes you may want to get statements from the claimant's family members. If they're a student in school, you want to get questionnaires, teacher questionnaires completed. My goal at this point is to obtain all the supporting documents I need so I can make it very difficult for the ALJ not to approve my client. So in closing thoughts, based on the information acquired during the interviews, the medical evidence, and our knowledge of the Social Security listings and grids and the rules, we are able to determine the best way to present a case before the administrative law judge for our client. And remember to keep calm when you're doing it. Thank you.
Thank you so much, Jackie, for your insight. Developing a theory of your case it can be a little tricky, and I'm glad you've broken it down to show that it's really an important thing to do, even at the initial level, to start thinking about why is the applicant eligible for disability benefits. So to dig a little bit deeper, we have Karen with the Greater Boston Legal Services, who is going to do part 2 of developing a theory of your case. Karen?
Yes, hello. Okay. So I'm going to go over things. You're going to see some things in the slides that are duplicative of what you've already heard. So I'm just going to skim over that and try and focus on some new information and some tips. One of the things in terms of the initial interview, I would just like to say, think as Jackie said, you want it to be very in-depth. I always reserve at least 2 hours for that initial interview. because I want to know about not only their medical conditions and things, but I also want to know about their past work, going back 15 years. I want to know about their education, and were they in special education, or did they graduate from high school? Did they graduate from college? Things like that. I want to know if they had any difficulty reading, writing, their math ability, and if those don't correspond with the level at which they graduated or ended school, I want to make sure that I'm able to highlight that to an administrative law judge. I also want to know in their work, why did they leave their last position? For every single one, why did you leave? And did you have any accommodations on that job? And within that, I also may, in addition to gathering medical evidence, I may want to get information in writing from their past employers to support their case if they had accommodations and things like that. So I want to have not only their mental health conditions fully known, but also their physical conditions, and how do all of these affect their functioning, and how does it apply either to, as we said before, in the 5-step sequential evaluation, do they meet a listing of any of that, or does the grid rules help them? And really knowing the rules around residual functional capacity is very important. You really want to know, are you arguing that their past work and their maximum capability is sedentary? Is it light work, medium work, heavy work, or less than sedentary? You're trying to get them into a category as low as possible, hopefully less than sedentary, or as people age, sedentary and light work might also find them to be disabled within the grid rules. These will all be very important when trying to determine your theory of the case. You want to know if the administrative law judge, when you go in front of a law judge, if they're going to decide to use the residual functional capacity that Social Security already assigned to the client at the lower levels of appeal, if they do that, what are your other arguments to find them disabled? And to do this, to figure out what my argument as to where their residual functional capacity will be, I always have my clients' doctors complete residual functional capacity forms, both physical and the mental impairment questionnaire. And I'm trying to locate where those will be here. I'm going to show you a residual. Hello?
Karen, this is Pam. I can open it up for you. Which one would you like to show first?
I was going to show the physical.
Okay, I'll open that up now. There we go. Can you see it? I opened it up.
No, I don't see it. Let me see. I clicked on it and I can see it now. Okay, so this is an example of a form that we use at Greater Boston Legal Services. Know that a couple of things are really important for you to know. When you send these forms, a form like this to the client's doctor, you have to, and you get it back, you must submit it to Social Security. You're not permitted, even if it's not helpful to your client's case, you are not permitted to withhold it. You must submit it. You also must submit to Social Security either a statement that you provided the form to the doctor or put your logo somewhere on the forms so that it's clear that it originated with you. This is important under the representative rules at Social Security, and you do not want to be found violating any representative rules at Social Security. it could have severe consequences on your ability to work in this field going forward. So within this form, you can see that we have like just general information on this first page about the client, what their disabilities are, their prognosis. This is an opinion of their doctor. When you look at medical records, it's very rare that a medical record will directly specify something, say that the doctor's limiting them to lift no more than 10 pounds, or that they can't stand for more than 15 minutes at a time or anything like that. You'll see more general things like they have a back condition that causes pain, but you won't get it broken down into that. And that's why these forms are very important, because Social Security will have already said what they think. And so you have to have something on your side that will be what the treating physician thinks. You'll see that they're on here, there's questions like, is your patient a malingerer? You know, are they to be believed about what their symptoms are? Do they have any other conditions that will affect their physical abilities, such as depression and things? If they have pain, will it impact their ability to concentrate? Then you'll see also these forms have some very clear things, like they would circle how many minutes at a time they can stand and sit, how far can they walk, and in an 8-hour day, cumulatively, how long can they do all these things? There's also some other questions on here, such as there's a fingering and grasping, but then how many times a month will they be absent from work due to their condition? This is one area, and I'm going to mention it again in a little bit, but we have found that at hearings, vocational experts who come to these hearings will always testify that, at least in the Boston area, that if a person will be absent from work 3 or more times a month due to their disability, they're not employable. So these types of things are very useful to obtain and probably will be found nowhere else in the record. Okay, and then the mental health questionnaire, I'll very briefly just show if we can see that. Can you help me with that, Pam?
Sure. I have it up now. Can you see it?
No, I see the physical.
Maybe that's something Susie can do for us as the host.
Oh, I found a way to, okay, there it is. Great.
Right.
So the mental health questionnaire is similar to the physical, but now it's focusing on mental health symptoms and how often you'll see them and things like that. This is very useful when you're trying to look at does somebody meet a listing or not under the mental health rules in Social Security. You can see how often they have these things. And then towards the end, you will see that it'll spell out the severity of how each of these symptoms impacts them. So that's also incredibly helpful. And you can look at it more later, but these forms I find are very powerful in a case. And goes to evidence of what their own treating source believes, you know, particularly someone who's treated the client for a lengthy period of time. It can be very helpful. Even though the rules at Social Security on how they look at treating source opinions have changed, it still is important to try and obtain these in order to be successful on a case. And so this has already been talked about, the rules about non-exertional and exertional impairments. So I'm just going to skip over that. This one here, for every job that the client has held in the last 15 years, you want to obtain, oops, what happened? Okay, I'm back to it. For every job that the person's had in the last 15 years, you want to look under the Dictionary of Occupational Titles, a description of that work. Now, in order to be prepared for the hearing and know how their past work was categorized, and then how does that their current abilities match with those abilities from the past, and then also look at their what you think the administrative law judge and the vocational expert will testify as possible jobs that they could do or not do. So you want to both be looking in the past as well as the future when looking at this. And what I find is you can get a lot of information just online. You can just Google cashier, Dictionary of Occupational Titles, and a description of that job will pop up. Because you also want to know, did the client perform that job the way it's described in the Dictionary of Occupational Titles, or did they perform it differently? I mentioned this before, vocational experts testify if the appellant would be out of work 3 or more times a month, they are not employable. I've also seen some vocational experts testify that they aren't employable if they're absent 2 or more times a month. But the 3 has been very reliable. They also testify that if the appellant would be off task 10 or 15% or more a day, they are not employable. And the off task, is something that those forms that I mentioned just a bit ago can really help you get to that information based on what the doctor is saying. Is there something that's going to impair them that will keep them from being on task? What's happening? And so you want to know the full medical record, as was said before, and match things that will fit with your argument. If your client has drug and alcohol addiction, either currently or in the past, you really want to build up evidence as to why that is not material to the current finding of disability. And this can be complicated, but for that, you'll need to be really asking about trauma history for your clients, anything that will have led them to addiction that existed prior to the addiction, or things like, a medical, some way in which the addiction occurred, or show that periods of sobriety where they still suffered from the same symptoms. Things like that are going to be very important. And then finally, really know the Social Security rules of representation so you do not find yourself in any ethical dilemmas. These are the 5-day rules. The 5-day rule says that you must submit all evidence, including a legal memo if you create one, 5 days before the hearing, 5 business days. And how witnesses testifying, you want to make sure that everything is truthful, because you have an obligation. If your client were to testify to something that isn't truthful, you must correct it. And so figuring out how you would correct it and making your client aware that that could happen. There are ways to do it without calling your client a liar or something. You could, ask to talk to your client separately outside the room and go over it and, come back in and just correct the testimony. Or you could, there's a variety of ways to do it, but you just want to make sure that nothing is said in your representation that's not truthful, that you are aware of that it's not truthful. we always write a legal memorandum that cites all of our evidence and our supporting theories, and as well as submit the evidence, as we said, 5 business days before. So that's all for now. Thank you.
Karen, thank you so much for your very informative dissection of developing a theory of your case. We did get quite a few questions that I'll save to the very, very end, which you'll be glad to hear about. So we're going to move on to Liam Connolly, Outreach Social Worker with Healthcare for the Homeless Veterans in Boston. Liam, you're up.
Hi, thank you. I'm really happy to be able to participate in this webinar, and I just want to make clear I'm participating as somebody who's very much continuing to be on the journey of learning how appeals work, particularly at the hearing level. I work with veterans who are experiencing homelessness, and I try to make sure that they get connected with care as well as get on a path to housing and get into stable housing. VA made a memo in 2017 that healthcare for homeless veterans employees could work as SOAR specialists, and I recall a very diligent SOAR specialist in Boston looking directly at me prior to this memo telling me I could do this. And so once it became public announcement that I saw in 2017, I decided to add it as a tool in my tool belt. But it was not very long ago that I was going on SOAR webinars to try to have a better understanding of how appeals work. So I am presenting on this webinar to share some of what I've learned at this point and some of the successes I've encountered, hopefully reaching other SOAR specialists who perhaps are in a similar position as I am, or as I was as I started reaching out and trying to learn more. So I get referrals from my team, which includes programs that include permanent supported housing programs where veterans have case managers in place. And so I was referred a veteran who was denied at the initial level, and so I started working with him at the reconsideration level. So I used the SOAR model at that point with what I had available and what I know. So I made sure to gather more evidence, do what Kate said, which was beef up the case for reconsideration, as well as make sure to include the medical summary report. And thankfully the veteran's psychiatrist, who is in VA provider as well, was willing to sign the MSR. Unfortunately, that reconsideration was denied. And lo and behold, I suddenly had to learn how to do the administrative law judge level of hearing. So I went about doing that, as I said in my opening, and was fortunate enough along the way to be able to connect with Greater Boston Legal Services, and asking if at the very least I could get some mentorship in terms of how the administrative law judge hearings work, perhaps sit on some hearings, and was very lucky to have Greater Boston Legal Services agree to represent two of them at the time my pending hearing cases. So in terms of my process of collaborating with Greater Boston Legal Services, who I may start calling GBLS, so talking about the same thing when I do that. My role, I learned within that as GBLS took point on representing the veterans, was to make sure to do a lot of the coordination between the agency and the veteran, and pretty much making sure that they were connecting and that GBLS was getting the records that they needed to. It's a privilege of being a SOAR provider in VA. As a VHA employee, I do have access to patient records to be able to review them, to be able to do a review for developing a theory of the case and completing medical summary reports. It doesn't necessarily mean that I have the ability to release them. That's up to medical records and HIMSS in VA facilities. So I make sure I'm working with the veteran on that in this process in relationship with legal aid. So it was a great educational opportunity for me as well. Karen was incredibly helpful with making sure to review residual functional capacity, grid rules, and as well as continue working on the record request to submit in the hope of a decision coming in lieu of a hearing. So not to brag or anything, but the decision for this initial hearing was found in favor of the claimant, in favor of the veteran. So it was based on the judge reviewing the evidence that was already in the file. And she took what evidence there was from both the initial and the reconsideration and was able to formulate a determination that was in favor of the veteran claimant. From the judge's notes in her decision, the medical summary report did weigh in that decision, which was good to hear, especially I'm sure SOAR providers understand based on the amount of time it takes to write a medical summary report. It's good to know somebody's reading it, and even better to know that sometimes it can help influence a decision. So the outcomes of this very positive development is that I have established a relationship with Greater Boston Legal Services, and I'm able to collaborate with them as I'm going to be moving forward with hearings and continue to learn from them for future cases that reach the hearing level. Hopefully not terrible many of them, but I'll be more prepared as they move forward with that. And also I'm hoping I can be of service to Greater Boston Legal Services as well for any veterans they work with experiencing homelessness. And also I would say I think in all honesty, my first hearing experience involved absolutely no hearing. The decision was made prior to the postponed hearing date. So I will certainly concede that, but it was very helpful to learn that administrative law judges have the ability to and do reverse decisions that DDS made, and certainly did in this case. So I have a list on this slide of some of the benefits of working with legal advocates. If not made clear, and having gotten to hear from legal advocates working within Social Security already on this webinar, working on the hearing level cases, certainly make clear that they have a great deal of expertise, and they can be incredibly helpful if they're able to represent the claimants who are at the appeal level. Within this slide, there's some information in terms of being able to have the representative be able to be paid if there's a favorable decision, even a partial payment in the cases where a claimant dismisses their representative. Legal aid agencies a lot of times can offer services for free. It does often depend on the case and the funding and the grants, but that can be a great resource for people with low income or no income. And certainly they come with a great deal of expertise. So in terms of if I'm in any position to give advice, and it's fantastic enough that I get time to be able to talk about myself to a few hundred people, which is great for my ego. But if I'm in an advice-giving position, it's my ability to work with Greater Boston Legal Services wasn't necessarily based on me just doing a cold call to the agency. in a typical fashion of me, it's a long story. It involves developing a friendly relationship with a woman on the bus that I took for work years ago, who turned out to be a law librarian, and was able to get me a contact for legal aid, particularly when I was trying to learn more about tenancy law in a job from a previous life. However, this relationship eventually developed in me being able to reach out when I had questions about trying to learn more about Social Security hearings for my practice as a SOAR specialist. That there was this opportunity that opened with Greater Boston Legal Services. So this is to say, certainly people have all kinds of relationships and opportunities that may be able to offer this sort of mentorship and representation. I was able to access in this case. It just doesn't necessarily always go through just calling the agency. Maybe in some other capacity of the work that we do, there's a relationship that can help, or maybe you too are friendly with people on public transportation, and it will open other opportunities. So basically explaining how once a hearing is requested, how the process works in terms of who's the representative. Most of the communication from either the field office or the hearing operations is going to be with the principal representative. And as a reminder, SOAR specialists can be very helpful in making sure to be that key in keeping all parties in communication, including the Social Security, the legal aid or legal representative, and the claimant as well. And of course, I note that some legal aid agencies may charge a fee. It's a good thing to know early in their representation. Again, I guess ideally this slide is for people like me learning the process as they go and have not yet contacted the Office of Hearing Operations. When a request for appeal at the ALJ level is made, it's submitted to the local field office, and then the Office of Hearing Operations will then contact the claimant and the representative. But I will make sure to include links for identifying field offices as well as hearing offices. There's an option which can be helpful to be able to get appointed representative services, or ARS, which gives a 1696 representative access to the electronic file online. It can be really helpful in easily citing evidence without necessarily having to wait on a disk to be sent, either from the field office or from OHO. And certainly it can help with things such as the on-the-record request and hearing prep in general, as well as citing evidence within the hearing itself, and having a good sense of the case and evidence on hand. So that ARS is requested by sending the SSA 1699 form, faxing it, and engaging in those services. So also for those who have Electronic Records Express access, the evidence that has been submitted through ERE can still be accessed through ERE. That doesn't necessarily mean that ARS services need to be in place either. Another good source of mentorship learning are oftentimes there's coalitions of disability advocates, other providers doing the sort of work that SOAR specialists do, and certainly I would say a great source of education has been the local meetings for SOAR representatives in Boston. It certainly was a front door and part of my very long story for this successful hearing. if there's one example of a coalition that can be really helpful in being able to learn more about hearings and increase skills. In Boston, there's SSI Coalition that the Disability Law Center administers, and so there may be these sort of groups local to you as well. And legal aid is knowledgeable about that oftentimes. So happy to share my success and a little bit of knowledge I have, and I'll be out there trying to get some more knowledge as I got more hearings coming up. Thank you.
No, Liam, thank you so much. We were so glad that you could round things out by talking about how you developed your relationship with Karen at Greater Boston Legal Services, and share some practical steps in, applying for a hearing and some of those more technical areas. So I'm sure many of you see yourselves in Liam and are on similar journeys in advancing your knowledge about how to represent an individual at the ALJ level. And as you can see, Liam didn't do it by himself. He really sought out some expertise through a legal aid and through Karen specifically in how to represent applicants, and again, working with him on how to develop a theory of the case. So thanks for sharing that. And our toolkit and other resources on the TA Center website does share some tips on how to collaborate with your with other legal advocates in your community. We have been getting some questions about that. Again, because we don't want you to feel that you need to represent individuals at the hearing level if you don't feel, comfortable and capable. It's not until Liam, again, really educated himself on the skill set needed to represent applicants at that level. So we're going to just end, before we get to the general Q&A, a little bit about representing applicants during COVID-19 pandemic. And Liam and Karen did put together some slides about this. And since these are, more temporary procedures, we just wanted to just let you know some key highlights. Understand that video and telephone hearings through September, possibly later, will be in lieu of live hearings while courts are closed to the public. So again, this may change, but information that we have is hearings right now will be by video or telephone. And to get more information, please visit SSA's website, specifically the coronavirus section, which will give you more information about postponements, requesting a postponement until a live or in-person hearing is possible, too, because that may be a choice that may not be as clear to the applicant. And you. So again, you want to be able to talk to the applicant about the pros and cons of choosing to delay until a live hearing can happen, or go ahead with that in person. So we provide some tips on how to go through that decision-making process with your applicant too. Liam, did you want to jump in? No? Okay. And again, here are some things to consider. Understand that it may take longer to obtain evidence. Request medical evidence records electronically if possible. That's a tip even at the initial level. Karen talked about that 5-day rule. You still need to get evidence in 5 days before the hearing. And if you are newly somebody who's just going to start representing an applicant with a 1696, SSA has modified some of their procedures to allow for a verbal attestation rather than a signed wet signature on the 1696. So we have the link to the letter, the emergency letter that Social Security sent out about this. So just make sure you're aware of this. And we would just encourage you to call your local Office of Hearing Operations, which is the hearing office, for information. And to give information as well. Don't neglect contacting the hearing office for their specific procedures that they may be in place, because all hearing offices are different. So they may have different days, dates for reopening and things of that nature. Liam talked a little bit about the appointment of representative services. That's something you really want to consider to give you access to the full file. And again, some tips on submitting a legal memo as soon as possible and request the case be reviewed for a possible on-the-record decision. But again, preserve that hearing date if a fully favorable decision cannot be made. And we got some questions about this, so we'll talk more in the Q&A about that. And again, don't hesitate to call the ALJ's clerk and inform them of the memo submission and the on-the-record request. They'll kind of give you some tips on that as well. So we're going to move now to the Q&A portion of the webinar. So we want to make sure that you know how to ask a question. So you may pose your question now to the panelists by typing your question or comment into the Q&A panel located on the right-hand side of the screen. If we are unable to get to your question, we will distribute to the appropriate panelist to answer afterwards with a follow-up response if we can't get to it. But we did get many questions about should I file one of those RFC, the residual functional questionnaire forms, the physical or mental forms that Karen was showing at the initial level. And the TA Center does not advise getting these forms sent in at the DDS level because, again, we utilize the medical summary report as well. So we don't encourage that. DDS may send a similar form to the doctor to get their opinion, but we don't have these forms. These are more useful at the ALJ level because they are designed in a way to be filled out easily by the doctor, but also the ALJ, the judge, does like to utilize these more at the hearing level. So we recommend, as Kate said, you know, MSR can win the day. So we encourage not substituting these RFC forms for a well-written MSR. And with that, I'm going to share, like, some of the questions that we got in were about how to get a doctor or an acceptable medical source to sign one of these RFC forms. Any tips on getting the doctors to complete these forms when you do have a case at the hearing level? And I'll throw that to, you know, Karen and also Jackie.
Sure. One thing I do is I do try and have a conversation with the doctor in advance and feel out whether they would be willing to fill out the form, and then also therefore feel out how they might answer the questions, because you do not have to tell the administrative law judge about verbal conversations you have with the doctors. If, you know, if the doctor verbally tells you, well, I'm going to say that they could do heavy work and they're perfectly fine and have no problems, then you don't want to send that form to that doctor. Because once you get the form, you have to submit it. But you don't have to tell the administrative law judge about your verbal conversations. I also will have my clients on their next appointment, because I make sure my clients have regular appointments with their doctors. I'll send the form with them. And therefore then, you know, since the client's right there, they might be more likely to also complete it.
Exactly. I do the same as Karen. Especially if I know it's a doctor who doesn't really like to fill out forms regarding the mental ability to do work forms, I will send it with the client, because the doctor doesn't want the client in his face the whole time asking, when are you going to fill out my form? When are you going to fill out my form? So they're more inclined to fill it out when the client takes it in.
Great. Thank you for that explanation. We have a question about, you know, to piggyback off of Liam's discussion of developing a relationship with Greater Boston Legal Services. So we have a questioner asking, I do the same thing with our local legal aid center. Do you have a formal MOU, Memorandum of Understanding, or agreement on your partnership? Karen, do you want to take that?
There's nothing formal in writing. We just agreed to, work together on these cases and talk about what works best with the client, and an arrangement where, even for the hearing, we would both attend the hearing together so that, Liam would have the experience of actually being at a hearing without having to feel like he was on his own. But yes, we didn't have anything formal set up.
Great. And I think, Jackie, is that the same with you with Community Health Law Project and getting your referrals from your SOAR?
We have a verbal agreement with Mercer County SOAR. We work together with the cases, with the clients. Diane is really good at making sure I get the records that I need, getting the client to the appointment, making sure the client's going to get to the hearing. Sometimes when I can't find the client, she's been really great at locating the client for me. So, yes, we work together.
Mm-hmm. That's great. You bring up a good point.
Even if she has questions.
Oh, go ahead, Jackie.
Oh, I was going to say, even if, because I don't take cases from her until they're at the hearing level. She'll do the cases up to the reconsideration level. But if she has questions, she knows that the people in our office are available to her. She can call us and ask us detailed questions regarding how to handle certain cases.
Thanks, Jackie. And we have a question, Karen. It says, and I think I know the answer to this, but does GBLS help applicants from other states?
No, we only help applicants from the greater Boston area.
Mm-hmm. I figured that. And that, I think that's a great question because I think Liam touched on this. Seek out your local legal services in your community. Even if it's in maybe a bigger city in your state, often they have satellite offices and telephone numbers and folks that can come do outreach and meet with you maybe at a local office. Any tips that you can share to help others coordinate, develop a partnership with their legal aid, like Liam, providing a mentorship, maybe shadowing you at a hearing so they can learn more about it. Any tips or experiences you can share with how you've done this with maybe other non-attorney representatives? And that's to Karen or Jackie.
Oh,
well,
I thought Karen was going to speak.
What?
Oh, I was waiting for you to speak.
Oh, I was just going to say that Liam's actually the first person who's reached out to us to ask for this this assistance, and how he got to us somehow caused it was a person from another legal services agency in the area who reached out to our executive director, who then forwarded me the Liam's contact information. So that's how that connection directly to me was made. But I think that you can see about what is your local legal services agency and things like that. Every state has one. But otherwise, yeah.
Okay.
Does that answer the question?
Can I just add to that?
Yes, please, Jackie.
Okay. I would call your legal aid office in your area, and I would ask them if you can come and have a tour of their office and that you're curious about what exactly they do, and then speak to them about Social Security and ask if you can work together and form a partnership.
Okay. That's a great tip, too.
Yeah.
And I also like, Jackie, what you said about the SOAR provider who assists you with the individual throughout the duration of the hearing. For example, knowing where the applicant may be residing, if you've lost touch with them, helping to get to appointments, submitting updated medical documentation, that sounds like a really effective working relationship on that case, too. We have a question here. Can you use OAT, which is the SOAR online application tracking system, to track appeals? And the answer is yes. So for those states that track their outcomes in SOAR using OAT, we are able to report on the reconsideration and ALJ hearings separately. So we encourage you to put in decisions for reconsideration and the ALJ cases. If you have any questions about that, certainly reach out to your SOAR local lead or your TA center liaison for more information. We have a question here. After an ALJ date, an administrative law judge date, a hearing date has been scheduled, do you recommend submitting a case theory and requesting an on-the-record decision? Do you want to answer that, maybe Karen, about that when a hearing has been set? When do you send an on-the-record request? And maybe that theory of the case might not be something that you send in, but maybe part of your hearing preparation. Can you kind of differentiate between that, the on-the-record request when you do that, and about the theory of the case?
Well, in terms of, before you get to the hearing, as early as possible, you want your theory of the case to be, to be clear. And then I would start thinking about doing an on-the-record request as soon as you have all of the medical documentation that you need. You have an obligation to submit all medical records that could pertain to disability to the administrative law judge. And so as soon as you're able to get that information together, I would start working on a legal memorandum to argue your theory of the case. And, if the case is such that the client's testimony is going to be absolutely needed before a judge could make a decision, it's not likely that you could get an on the record. But if you see that you can argue that the client meets a listing, or for some other reason, have clear evidence within the paper file to argue disability, then I think it's worth trying to make a request for an on-the-record decision. And you want to specify that you're requesting that, and also specify that should the decision not be favorable, you will go forward with the hearing, so that they don't just write a negative decision without a hearing. But yes, as soon as you're able to do that, it's worthwhile. And especially under COVID, judges right now are really trying to see, are there any cases right now that they could issue an on-the-record decision on?
Right. And can I just add something to that?
Please do, Jackie.
If you don't mind. Even if the case hasn't been assigned to an administrative law judge yet, and it looks like a very strong case from the medical evidence, I will contact the hearing office and ask if I can submit an on-the-record request to the attorney advisor, if there are attorney advisors in the office. I know some offices don't have them. Or what they'll do is they will give it to, they're expecting it, so they'll give it to the chief ALJ, and he will assign it to one of the attorneys to review. One of the judges to review, excuse me.
Great. Thanks, Jackie. I think that's a wonderful tip, and we do have some of these suggestions in the Appeals Toolkit under the on-the-record section with a sample on-the-record request. But I think that's a great tip. Often we hear from SOAR caseworkers who file the request for a hearing with the plan to hand it off, do a soft handoff to a legal aid advocate. But in the meantime, they might do an on-the-record request. They may turn their MSR, adding more information about a theory of the case and some of the rules that, our panelists today talked about. Send that to the hearing office, and an on-the-record decision will be made without needing to hand it off to anyone. That SOAR provider, due to the strength of the case, the ALJ or the attorney advisor felt this can be a fully favorable decision. And we hear that quite often without having to actually go to a physical hearing. So that's a great point, and we do have some more guidance on that as well. We have a question here that has come in, and this could be applicable to a reconsideration appeal or even an ALJ appeal. But the question is, if my client has a newer diagnosis that clearly meets a listing, do I have to start from scratch with a new application, or can I shift to the new listing and appealing with an ALJ? And I'll also add a recon. Does somebody want to take that question about you find out there's a new diagnosis?
I can't speak to the ALJ level, but at the reconsideration level, no, you need to start a new application.
I could say that at the ALJ level, you could absolutely add something to the case, add the new diagnosis to the case. I had a client who recently, she already had some various issues, but then while we were waiting for a hearing, she developed breast cancer, and that became one of the items by which the judge ruled in her favor.
Okay, thank you. Okay, so we have a question that came in about, let's see, the question came, we have a lot of questions about the RFC forms, and hopefully, even though we have those shared for you, those can be really helpful, again, at the ALJ level. Very useful at the ALJ level. Here's a question about, I have an applicant who has been denied previously and has a case open right now. I'm not sure if it's an appeal or not. Where do I start? So again, I'll just answer that really quickly. The first place you want to start is faxing the SSA 3288 request for information to your local SSA field office. They will tell you the status of the current application, because it's my understanding that an applicant can't have two applications going at the same time. Karen or Jackie, do you have any input on that? Filing a new application when one's already pending?
When there's already one pending, you are correct. You can't file a new application unless they already had a SSI application pending, and then they later filed a SSD application. But they should be put together so they're moving at the same pace.
Right. Okay, and here's a quick question. This might be our last one. If you are taking on a case which already had a representative on file, do you need to submit a new, 6096, or how do you, quote unquote, fire the representative? And this may not be a question that you can answer, but we see it come up where the SOAR advocate does want to take over the case for whatever reason, and they're already represented.
In our office, they have to fire their representative first, and they have to bring a letter in to us showing that has happened, and that it was submitted to Social Security before we will even look at the case.
Gotcha. Okay, that makes sense. So we do have information in the toolkit about how to handle that situation. So it looks like we are out of time. We do have questions that we weren't able to get to, but rest assured they will be. We will respond to you within the next few days to get your question answered. So we'll be reaching out to you about that. So again, on behalf of the SOAR TA Center, I do want to thank our panelists for taking the time to create such excellent presentations. Again, please do not hesitate to contact the SOAR TA Center anytime for more support with implementing SOAR within your area. And again, we thank you for joining us today, and have a great rest of your day. Thank you so much. And also remember to fill out the evaluation too. Thank you.